Start. Rule 14 within bracket 2 states that minor penalty may be imposed after informing the police officer in writing of the action to be proposed to be taken against him and what imputation of the act or omission on which action is proposed to be taken after giving him reasonable opportunity of making representation. Full stop. In UP, police officers of subordinate ranks within bracket punishment and appeal bracket close rules, 1991, there is no provision akin to the provision of 34.2 of the discipline and appeal rules, as discussed in the case of Rabindranath Chaube within bracket Supra bracket close full stop. Even the civil service regulations does not contain any such rule or provision which may permit passing of order of dismissal or for that matter any other penalty in case the employee has retired. Full stop. Learned State Council has also not been able to place any such rule before us. Full stop. In absence of any rule, which permits imposition of punishment of dismissal after retirement or which deems the employee-employer relationship to be continued even after retirement for the purposes of disciplinary proceedings, in our opinion, the judgment of Honorable Supreme Court in the case of Rabindranath Chaube within bracket supra bracket close does not have any application in this case. Full stop. Accordingly, the reliance placed by the learned State Council on the said judgment is misplaced. Full stop. As already observed above, Honorable Supreme Court in the case of Prabhakar Sadashiv Karwade within bracket supra bracket close has clearly held that penalty of dismissal cannot be imposed on an officer slash employer after his retirement after attaining the age of superannuation unless there exists a specific rule in that behalf. Full stop. If the disciplinary inquiry is instituted prior to retirement of the employee concerned, the same will continue by operation of Article 351A of Civil Service Regulations as held by Honorable Supreme Court in the case of Harihar Bholenath within bracket supra bracket close full stop. However, in such a case, if the employee is found to be guilty of grave misconduct of or is found to have caused pecuniary loss to the government, it is the governor who can take action as provided in Article 351-A of the Civil Service Regulations. Full stop. Admittedly, in the instant case, the proceedings were instituted prior to retirement of the appellant petitioner, however, prior to passing of the order dated 1/11/2018 reiterating the order of dismissal, he had already retired on 31/5/2015 on his attaining the age of superannuation and accordingly after 31/5/2015 the employee-employer relationship had already got severed and thus only action permissible against him is in terms of the provisions contained in Article 351A of Civil Service Regulations. Full stop. Learned single judge, while passing the judgment and order under appeal, has not addressed the aforesaid issues, though these issues were contended not only in the writ petition but even in the replies submitted by the appellant as petitioner to the so-called notice dated 22/5/2018. Full stop. Learned single judge, while passing the judgment and order under appeal, appears to have lost sight of the aforesaid aspects of the matter and accordingly, in our opinion, judgment rendered by the learned single judge is not tenable. Full stop. Resultantly, the special appeal is allowed. full stop.